Welcome to this morning's program, Shaping the Defense, Strategic Jury Selection for Trial Victory. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association, and today I am delighted to introduce our speakers, Keith Bremer and Vic Nagpal. Keith Bremer is a founding partner at Bremer, Whyte, Brown, and O'Mara, and an acclaimed trial attorney recognized among California's top 100 attorneys, with a long record of success in major civil, commercial, and high-profile litigation. A member of ABOTA and the Litigation Council of America, he has earned numerous honors, including 17 consecutive years as a super lawyer, and is frequently sought after nationwide as both a legal commentator and featured speaker. Vic Nagpal is the managing partner at Bremer Whyte's San Diego offices, where he leads the firm's business development and handles cases involving complex general liability, construction defect, catastrophic injuries, toxic torts, and business litigation, just to name a few. With more than 2 decades of experience, he frequently provides training and seminars to the Department of Insurance on issues relating to his vast practice area. We can't wait to hear what they have to share with us today, so I'm going to turn it over to them.
All right. Well, good morning, everyone. I hope everyone's doing well this Thursday, Friday Eve. Again, my name is Keith Bremer. My partner, Vic Nagpal, I've had the pleasure of sitting next to you for over 20 years, and I love him. We're a majority defense-oriented law firm. So today I'm going to be talking about defense, about voir dire from the defense perspective. But a lot of times we do these seminars and it's majority of the attendees or the people that participate are plaintiffs or plaintiff lawyers. So I want to talk a little bit about being a defense lawyer. First of all, it's a very tough job. Sometimes you have to defend absolutely terrible cases. And so you can have admitted liability, horrific injuries, and your back is to the wall. The second part of being difficult is that we always go second. So great plaintiff lawyers get to go first in terms of introducing themselves, in terms of voir dire. They get the last laugh with regard to a rebuttal closing, and we're always second. So plaintiff's case in chief is going to go first, and we're going to sit there and just hope that we're not getting killed too bad. So I want to talk a little bit about how do we handle those difficult cases? How do we handle being second? So there are some changes in the law, and almost all judges now are respecting that in terms of if there's a request for a meeting opening, that the judge will then not provide the opening statement, a stipulated statement. Instead, he'll allow each counsel to do a 2-minute opening statement. From a defense perspective, that's actually pretty good because for once we get the last word before we go into voir dire. So plaintiff would go first, have a 2-minute opening statement, and then defense would go. I would caution everyone on that opening statement to really be careful about not arguing, to try to stay neutral, to not polarize, anything like that. So there's that issue. And then we go into voir dire. Obviously, the judge would start the voir dire, and then the plaintiff would go first. So why is it a terrible job to be a defense lawyer? It's not a terrible job. It just can be very, very difficult or very hard. Let's talk about a clear liability case. You know, as a defense lawyer, we have so many different hats we need to wear. The client is in a really, really difficult situation, and we need to be, sympathetic with regard to where he or she is at, their company might be at. We have to deal with issues concerning insurance, no insurance, whether or not there's a reservation of rights, media, personal exposure, punitive damages. So there's a number of different things that we're juggling at the same time that we have to handle as a defense lawyer. At the same time, we have to consider the case, the facts, circumstances, and our presentation, which I'm going to talk about. Where liability is admitted or acknowledged, it's important to acknowledge that someone's made a mistake to the jury and that we represent real people and that we too seek justice. I love that plaintiffs pound their chest and always say they're seeking justice. Well, we seek justice just as much, and I make a point of saying that. Our job is to be their advocate and to hopefully do the best we can to mitigate their damages, including from among other things, we get involved in a rapid response program, meaning that if there was a truck accident that happened tonight, a large number of carriers have our contact, clients have our contact. I am a member of TITA, and so I will get contacted in the middle of the night. We'll have a rapid response. So we're getting involved really, really early. From a defense perspective, we're doing mock trials, we're doing focus groups on issues. We're acting as monitoring counsel on a tower. backing up a primary counsel, and we might even be brought in a fire situation last minute to try to take over and kind of help out. So there's just so many different hats a defense lawyer has to wear in order to be totally prepared for the case and understand everything. Where there's a question of liability or damages, it's a little bit easier because you have a little bit more to argue. You can talk about shared responsibility and things like that. And we're going to talk about how to handle that and sell that in voir dire. When we talk about shared responsibility, one of the things I like to do at the end of voir dire, my last question, is act like I'm almost done and then say to the jury, does anyone here disagree that two people can be responsible for an accident? Is that a fair comment? Does everyone agree, by a show of hands, who agrees that two people can be responsible for the same accident? And so I kind of leave that with them. So I'm kind of jumping ahead a little bit only because I was talking about where there's questionable liability, and I want to talk a little bit about voir dire. Consider a last question that resonates with the jury and makes them think about things. But from a defense standpoint, we have the questionable liability, and then we have the questionable injuries. Whether or not the plaintiff had pre-existing and now they're trying to piggyback on the pre-existing. Is it an exacerbation? Is this an eggshell plaintiff? We have to look at that. You have to look at the CACI instructions. You really, really need to understand Casey before voir dire. You need to understand what the instructions are, what's going to be read to the jury. Most judges will read preliminary jury instructions, a handful of jury instructions prior to voir dire or prior to opening. So you'll have to ask your judge. Some judges will not. So be aware of that. From a defense perspective, again, getting involved early in terms of looking we have great experts in terms of accident recons, biomechanics, orthopedic surgeons, neurologists, neuroradiologists, etc. So building the right team. So let's talk now a little bit about voir dire. Everyone has a different approach to voir dire. For those who are attending this event, I'm sure that you've listened to 5, 6, 7 other speakers. I've probably listened to 20 different lawyers talk about voir dire. Everybody has a different tilt. Let me say this. The practice of law and voir dire is an art. And the question is, what kind of picture are you painting and what do you want the jury to see? And remember, it's not important as to what you say. What's important is what is received, what is heard, what resonates with that jury. So stop patting yourself on the back if you said the right things. If you haven't communicated something that resonated with the jury, you failed. So remember, what is the jury hearing? And so that's hard for us as lawyers because we like to buy our own BS, so to speak. And so you've got to get out of that silo. And that's where the mock juries, that's where the focus groups really help. That's where talking to friends, talking to colleagues, talking to people on the other side of the bar and running issues by them and getting their ideas. So for me, voir dire is about building a rapport. I call it the tribe. Some people disagree with that approach, but for me, I think it's really important to build a tribe. Obviously, my goal is to weed out bad jurors. My goal is to take advantage of for cause versus my preemptory challenges. For those who are not aware, we're only provided 6 preemptory challenges per side. So if there's more than one defendant, you could make if you can make a colorable argument that there's 2 sides, you may get 12. Some judges may give you 6 or 3. They could break them up. But what you want to take advantage of, obviously, is the for cause challenges. And we'll talk a little bit about that. I know a lot of people talk a lot about that. My focus in voir dire is to build a tribe. And what does that mean? I'm a staunch believer you have to be authentic. If you're not going to be real, if you're not going to be yourself, I think you're going to fail. So as much as I think John Morgan is amazing and I'd love to do everything he says in his podcast and follow along, and by the way, I steal a ton of his stuff and I'll be talking about that, I still have to be me. And so be authentic. With regard to being authentic, I think it's important as a defense lawyer that you appreciate empathy and what that means. Real empathy means you stand in the shoes of the plaintiff and what he or she went through, felt, smelled, touched, saw, where they come from, how they were raised, how far that apple fell from the tree, so to speak. I think credibility is probably everything. So the reason why I feel it's so important to build a tribe is that if first of all, I think when you get up in voir dire, you only get one chance to make a first impression. So make sure when you get up there and your first 20 to 30 seconds are impactful, that you're authentic, that you're real, and that you're trying to let them know that you genuinely care about the outcome of this case and you want justice. And that for me, I'm empowering this jury. So that's probably my biggest takeaway for me is I'm building a tribe and I'm empowering them. I love the system. I love the process. I love finding justice. But that
And
only
Keith,
works with the jury.
Keith, along those lines, about you have that first impression. I think always for us, and I've learned a lot from Keith, who's done tons of trials, is we want our client present during voir dire. So we want to humanize our client. We want the jury to see that they think that this is important to them. We want them to get to know our client. And where I think on the other side, on the plaintiff side, sometimes they do, and sometimes they don't want their clients there because there's a perception that the jury's watching every move that that plaintiff makes, how they get up out of their chair, how they walk in and out of the courtroom. And potentially, I think from the plaintiff side, there's a concern that this jury pool is predetermining the validity of their alleged injuries. So there's definitely a difference. I think from our side, we generally want our client there all the time, be able to introduce them and let the jury get to know them as much as they can. And then along the same lines, I know Keith is going to be getting into the questions and sort of things that we look at and talk about and sympathy. I would also caution that like you should pay close attention to nonverbal cues as well. So when Keith gets into responses that we're getting or questions that we're asking and whether we're setting someone up for a cause, also pay close attention to the nonverbal cues, facial expressions, and their overall demeanor, because I think that provides valuable insight into a juror's attitude that their words might not fully reveal to you.
Thanks, Vic. So I want to go back to building that rapport in that tribe and that first 20 to 30 seconds of coming out there. So for me, it's being authentic. And again, I have this love of the system. I love the process. And so as a defense lawyer, I always speak about how do we evaluate and value a case, because that's our job. And our job in a tripartite relationship, if we have a client, an insurance company, and then our representation, the tripartite relationship, our client is our evaluation of the case, because the carrier wants us to say one thing, the client wants us to say another in terms of whether a policy is going to be open, not open, et cetera. Our job is to evaluate and value the case. So every case has a value every single day, and that value changes every single day based on the facts and circumstances and evidence that is learned, i.e. discovery through a deposition, response to interrogatories, change in plaintiff's physical condition, plaintiff's presentation in the deposition. All of that in comparison to what would a reasoned jury in that jurisdiction do at this time. So I'm always looking to where's the jurisdiction? Who's the judge? Am I in a conservative venue or am I in a liberal venue? But because I'm looking at the jury. So for me, I want to empower this jury to appreciate that I appreciate the system and the process. I love that they're there. I know they don't want to be there, but I know they're going to love that. And I'm going to talk about that in a second in terms of them not loving to be there and how I play that. But I want to go back to the tribe. So for me, I tell the jury, look, today is going to be an amazing day for you. You are going to be the judges of the facts. You are going to sit as the judges. Now, the judge is going to give you the law that you're going to follow. He gives you the law or she gives you the law, and then you'll follow that law. But you'll apply the facts and circumstances of this case and the evidence that you get from that witness stand right over there to this case. And that's a pretty awesome amount of authority, a pretty awesome amount of power, and you get to do justice in this case. And while I may give you recommendations as to what I think the evidence is going to show or what I'm doing in terms of this case, ultimately, you're going to be the judges of the facts. And I respect that. So for me, the first 20 to 30 seconds when you come out, I think you've got to have a spiel. And I'm going to get to that in a second. I'm going to talk about that first impression and what you should do. I want you to feel comfortable. Everyone should feel comfortable. Because if you go out and you're going to do a John Morgan first voir dire, it's not you. You're acting. It's not authentic. So you need to have something that you can really, that's visceral, that's you, that you believe in, that you're going with. So we'll talk about that in a second. So before you start voir dire, you have to start thinking about your case. And one of the things I want to talk about is for us, we're proactive. So we're offensive as a law firm. We're not defensive. So I guess I do care, but I barely care what plaintiff is doing in terms of a 2-minute opening, in terms of the voir dire. I have my themes and I have my story, and I'm going to tell a story. So let me give you an example. One time I tried a case against a fantastic trial lawyer in San Bernardino. His name is Bill Shapiro. And Bill got up, and it was a TBI, a clear liability case with a TBI on a T-bone. And I really liked the case. I really liked where I was going. I really liked my arguments. And Bill got up and did a 45-minute opening that was the best opening I'd ever heard. And I started sweating. The judge said, "Do you want a break?" I'm like, "Yeah, I need a break. I'm going to throw up and go to the bathroom. I'll be back if I don't have a heart attack." And I thought about rewriting my entire opening again and changing it and being reactive. But I didn't do that. I was offensive. And I'm going to be consistent, and we're going to be consistent as a law firm in terms of doing that. We appreciate that plaintiff has themes, plaintiff has a story they're going to tell, but we have our themes and our story. So as amazing as, let's just keep using John Morgan, who is a legend as our example, does a phenomenal 2-minute opening. I've got my 2-minute opening. I've already done it. I've already thought about it. I've thought about my thematics. I've thought about everything I've done, and I'm going to move forward with what I'm going to do. Same in voir dire. Now, that's not to say that I'm going to abandon addressing certain things that are brought up. The great plaintiff lawyers bring up a number of things. They set a number of traps, and you have to be aware of them, and then you interweave them in with the theme and the story that you're going to tell and what you're trying to accomplish in voir dire. Now, look, don't try to accomplish too much in voir dire. A lot of times people go in with one goal. I'm going to get rid of jurors for cause. And it's almost like a sport. I think you're missing the point. The next thing is a lot of lawyers go into voir dire saying, "I'm going to communicate a message. I'm going to win this case in voir dire. I'm going to start to really plant some seeds." First of all, most of the judges aren't allowing that these days, and they're going to shut you down. And the second thing is that you're going to get off track, and you're going to lose sight of what you're really trying to do, and that's find the right jurors for the right cases. So first thing you want to do is identify what is your juror profile. What are you looking for? From a defense perspective, I'm not going to give you anything you hadn't already thought about. You have like business owners, managers, guys who care about budgets, fiscal responsibility, frivolous lawsuits. They're less emotional. They're more pragmatic. You like engineers. We like accountants, detail-oriented professionals. They like objective proof, right? Listen, the other thing I want to tell you is just because somebody else has suffered a similar injury in a case doesn't mean you want to throw them out with the bathwater. And when we talk about bad cases, I just got out of trial in the city of Modesto on a child molestation case. By far the worst experience of my life in terms of trying a case. I hate it. I didn't like anything about it. Facts were bad. Evidence was bad. Horrible experience. But in that case, when I talked about what's the perfect profile, initially I thought anyone who had been molested or anyone who had a family member or a good friend had been molested. And by the way, the questionnaire we sent to 60 people, and 26 of them either personally were molested or had a personal friend or family member that were molested. So I had a lot to work with there. But the truth of the matter is that some of those potential jurors were pretty good jurors. They went through a traumatic situation when they were in 3rd grade or 4th grade, but they processed it, they went through it, and they're way better, and they've moved on. In my case, I had a plaintiff who, I hate to use the word malingering because everyone's going to say, "Oh, it's such a defense comment," but someone who I thought was utilizing that to tie all of their ill wills or all of their bad luck in their whole life to, and didn't take any personal accountability for trying to make a difference or make a change and go in a different direction. So just because someone else had been in a motorcycle accident, just because someone else had been molested, don't just write them off. Look at the impression of that person. In fact, I just did this seminar, one just like it, with Dan Kramer the other day, and we were voir diring an individual, and we talked about the fact that the plaintiff doesn't speak English. And when we voir dired, somebody said, "Well, I'm initially a little critical of someone who's been here 20 years that doesn't speak English." And then as we voir dired that witness, we all concluded that that would be a good juror for the plaintiff in this case. So while we started off thinking that juror doesn't work, so don't write people off right away. Be open to it. Be receptive. Again, you're trying to start a dialogue and build a rapport. For me, I'm building a tribe. And what do I mean by that? I want them to believe that I'm someone they would hang out with, someone they would rely on, someone that they might ask an important question to. And if they trust me, and I want them to trust me, and I'm being authentic, then they might let a little bit of that wear on my client. They might throw a little bit. So if my client doesn't do so well on cross, If my client doesn't present so great, if the facts aren't great, maybe the client gets a little bit of the benefit of the doubt by 2%. I'm not saying it's anything significant, but again, I've got a job. And my job is to do the best job I can for my client, and that means maintaining authenticity and professionalism. And along those lines, most lawyers lose it in voir dire. If I say that I've seen lawyers lose it, sure, I've seen cross where they've lost it or a witness that wasn't going well. But it's in voir dire sometimes when a juror doesn't give him or her a simple, easy answer that's so elementary. And so, for example, I understand you don't like police officers, but you'd agree that on occasion, you might need a police officer. In fact, have you ever needed a police officer in an emergency situation? Never. Have you ever thought that there are people that needed a police officer in an emergency situation? Probably not. And you want to go, what is wrong with you right now? Clearly, that's okay. You know that there are police officers who add value on occasion, right? So you don't ever want to do that. This is the perfect example of why we went to law school and what we've learned to be pragmatic, is to be patient and understand. And listen, in trial, we've got a gun firing out our head. That gun is coming from the judge. It's coming from the jury. It's coming from the plaintiff. It's coming from my client. It's coming from the insurance carrier behind me. It's coming from monitor counsel behind me. It's hard. And there's a lot of pressure in that cooker, but you got to keep your cool and you got to work with the juror. Do not fight with the juror ever. That is terrible. Okay, so then we already talked about the good jurors. Now let's talk about the bad jurors. You've got to lay out what are the red flags you're looking for. Who are the jurors you don't want, and identifying what those red flags are. Vic, where are you at?
No, I totally agree. And like just before we move on, you're gonna ask all these questions to jurors, and I agree. If you don't get an answer that you don't like or think it's a bad answer or response, don't just move on. You need to talk through it, because I think what you do is you'll shut off more jurors than you realize at that point if you do that. And even when you're asking all these questions, there's never any guarantee of who you're going to get, right? You're going to do your best job. You're going to ask these questions. You're going to try to delve deeper into their background or why they feel a certain way. But at the end of the day, there's never a guarantee of who you're going to get. So, for example, we had a case, this was a while ago, it went to verdict with 3 parties. And we were excited. Personally, I was excited to have a juror who was a paralegal, because there were some contract terms that were at issue, express indemnity, and we thought that she would have the legal acumen to understand that. It was like a hybrid real estate case. I was like a sick house because there was some physical injury components to it. So in closing, plaintiff used an analogy that this was their client's dream home, and when they finally got into the home, it was more of a sick house, because once they moved in, it was just full of problems, not only from a physical injury standpoint, but from the way the house was built. So he used an analogy that this home that they bargained for was a home that fell off a truck because it had so many problems. So long story short, we got a defense verdict. The other defendant got hit pretty hard, and we had an opportunity to pull the jury afterwards. So we went up to the paralegal juror that served, and we found that, asked her the general questions of, why'd you rule this way, or what did you like, what didn't you like, and then why did you find in favor of the plaintiffs versus the other defendant? And her response was, because the house fell off a truck. She actually believed that. So my point is that although we're trying to do our best by asking questions, there's absolutely, as everyone knows in law, there's 100% no guarantee of what jury you're going to get or what they're actually thinking. Now, if you're asking questions to a juror and you like what they say, so there was another case that we had with one of our other partners, and that case was dealing with someone who claimed that they were injured by a dart in a bar. So during voir dire, our partner asked if anyone thinks having darts in a bar is inherently dangerous. And a specific juror said no. And then she started talking about how she's been to bars with axe throwing. And so that was great for us. And then she talked about how, people need to start taking responsibility for their own actions. So when we like a response like that, we just, we ask them what else, and we take them down a path that's beneficial for us. And surprisingly, she made the jury, and that's probably because the other side didn't take her down a path to get her removed for cause or with a peremptory challenge.
So we'll get into that in terms of for cause, Vic, in a sec. I want to
Yeah.
talk about that first impression now. So again, for me and for our law firm, when we get a new case in and it's a bigger case and we see it's one that's gonna go down the road a little bit, we definitely have a roundtable meeting and talk about what are the themes of this case? What's our story? What is the story that we're going to tell? Where are we going? And then we organize our thoughts with regard to what those themes are and how we're going to run those themes through discovery, how we're going to run those themes through the deposition, how we're going to do that by way of direct evidence, cross-examination, trial, etc. And we weave that into our story. So when we start off in voir dire, you're going to have that first minute to introduce yourself and to talk about your theme or your story for just a second. And I've just got a few that I just are my quote unquote go-tos with regard to what is the case. So let's just say it's a case that I think is a highly questionable liability case. Great damage case, but a highly questionable liability case. Maybe a slip and fall on an arguably open and obvious condition with a significant injury. So one of the things I'll say is, ladies and gentlemen, my name is Keith Bremer. I represent, Joe's Diner here. Joe's with me. I can't wait for you to meet Joe. Joe's a great guy. He's owned the diner for 20 years. Don't forget, motions in limine are going to be heard about 5 minutes before this voir dire. Let's assume that in the motion in limine, I got in that I could talk about the fact that there's been no other accidents ever. And Joe's going to tell you in his 20 years, he's never had anything like this ever happen. And this has been a horrible situation. We're certainly empathetic and sympathetic to the fact that plaintiff was significantly injured, but it's our contention that we didn't do anything wrong, ladies and gentlemen. So with that, does anyone here believe that just because we're here, Joe or my client might have done something wrong? We have voir dire, we have a judge, I'm wearing a tie, I generally don't wear a tie. Does anyone believe just because we're here that we must have done something wrong? No one raises their hand. I then push a little bit. So listen, today in voir dire, I'm just as nervous as you are. This is a difficult situation. What we're looking for is the right juror for the right case. And I need everyone to give me some honesty and just to be open as much as you can, and I'll be open as well. This is, the no harm zone. You can say whatever you want to say, and you're going to be okay. Clearly, there are people out there that think that potentially my client must have done something wrong or we shouldn't be here. And I appreciate that. That's a natural, normal thing for someone to think. Does someone agree that someone must be doing something wrong or we wouldn't be here, right? Fair. Now you're going to get someone to raise their hand. You're going to say, thank you, juror number 3, Vic, I appreciate that. But I want you to appreciate that this is our system. And I love our system, ladies and gentlemen. Our system's amazing because you are the judges of the facts and you get to determine whether or not this case should be here or it shouldn't be here. And we take the position that this is a case of no liability, but we believe this is the right place to have this case heard. And we don't want vigilante in the street. We want justice, and you're part of that justice. Does everyone appreciate that? So you haven't heard any evidence. You don't know anything. And so plaintiff hasn't met any burden of proof. The slate is clean right now. Just because we're here doesn't mean anyone did anything wrong. It's that these two parties have a dispute amongst themselves, and we need your help as the judges of the facts to determine where we're going. So that might be one way that I start the trial. Another way I might start the trial is just to say, hey, ladies and gentlemen, my name is Keith Bremer. I represent Joe's Diner. Love Joe. I can't wait for you to meet him. He's going to make a great witness. He's a great guy. He's genuine. And we're certainly empathetic about what's going on here. So this is voir dire, and voir dire is a weird word and confusing, and I'm sure a lot of you are intimidated, and I'm intimidated. And there's a lot of pressure to be here. Voir dire means speak the truth, but that's not really what we're doing here in voir dire. What we're really doing in voir dire is determining whether you, the juror, a potential juror, is the right juror for this case. So let me give you an example. So not all jurors are the right jurors for a particular case. Say, for example, that I was asked, I told you I'd bring up John Morgan, I was asked to be a judge in a pie eating contest. Well, it turns out I don't like cherry pie. So I wouldn't be the best pie eating judge because if you made a cherry pie, you're going to be sunk as a result of that. Or let's say that you were involved in a motorcycle. This is not a motorcycle case. Let's say that you were involved in a motorcycle case a year ago and you had a terrible recovery. It was horrible. And you are extremely critical of people on motorcycles. and this is a motorcycle case. Well, you wouldn't be the right juror for this case. So what we're doing in voir dire is we're going to ask questions to determine whether or not you can be fair and impartial in this case. And let me talk a little bit about being fair and impartial. What that means is, since we haven't heard any evidence, and all the evidence is going to come from that witness stand back there, we have two white blank pieces of paper in front of us. Nobody it has anything written that gives anybody an advantage. It's as if we have two horses at the starting gate at the exact same place. No horse is ahead of the other. And that's what we want. We want a jury that's fully impartial before we get started. Once the evidence comes in, that's going to change. When I do that spiel, I then move into the next spiel, which is I'm the defendant, ladies and gentlemen. And as the defendant, I go second. That's the way the system works. We can't both go at the same time. So plaintiff's going to go first, and I'm going to go second. So one of the key things that I need from you is, can you be patient? And I'll tell you what, life is interesting, isn't it? We all have first impressions, right? This morning, I went to Starbucks and I ordered a latte. And so I walk up to the counter and I looked up at my barista, and she had 3 earrings in her nose. She had a big feather. Half her hair was purple and half her hair was black. And I'm like, I don't know that you're the best person to make me a latte, but I'm here, and I ordered the latte. And when I got the latte, she had this beautiful heart in the latte, and it was the best latte I ever had. So my first impression, or my quick judgment, would have been off. And that's how this trial is. You have to be patient. And one of the things the judge is going to say to you, the judge gives you the law that you have to follow. One of the laws the judge is going to give you is that you're not to talk amongst yourselves. You're not to talk at home, to your friend, to your spouse. No Google searches, because we want you to get all the facts and evidence in this case from that witness stand after all the evidence comes in. Since plaintiff goes first, it's easy to make a quick judgment and go, oh, I don't like that coffee at all, or I don't want that barista at all. Be patient. Wait. If you love what plaintiff has to say, that's great too. But I'm going to get up next, and I'm going to do the cross of that witness. Then there's going to be another witness, and it's all going to come together. So you have to be patient to see whether or not you like the coffee at the end. And by talking to each other, or by not being patient, then you start to form opinions based on those conversations, or talking to someone at home, or Google searching, or any of those things. We don't want that. We want you to hear the entire case. So patience is such an important part of this case. So hard to do, because we all make first impressions. I did it this morning, but I could tell you I had the best latte, and I'm pretty fired up right now. So that's another way you can kind of get started and go where you're going. Vic, did you want to chime in at all?
No, I think that's right on the mark. That's exactly what I was going to say.
Okay. So, and it's nothing wrong with saying, getting up there and say, hey, my name is Keith Bremer. I've got Joe's Diner. Hey, it looks bad in this case. I'm not saying it doesn't look bad, ladies and gentlemen, but I need you to keep an open mind, because we definitely have a case here, and we take the position that this is a case of shared responsibility. That plaintiff too is responsible for this accident, not just my client. And can everyone keep an open mind now? Can everyone be patient and let plaintiff put on his or her case? Then I'll do my cross, then we'll go to the next witness. Then plaintiff's going to rest their case, then I'm going to put my case on. And then we're going to have closings, etc. You have to wait to hear everything come together, to see all the puzzle pieces come together before you make a decision whether or not you like the picture in the puzzle, or whether or not the coffee tastes good or not. Can everyone be patient and do that? So find your own spiel with regard to what you're doing, because you want to make that first minute comfortable for yourself, because you want to get the butterflies out. Everybody's nervous. John Morgan said it himself. There isn't a trial he doesn't get up real quick in the voir dire for that first second or two and get nervous. And if a guy like him gets nervous, well, that's a license for me to stay nervous the entire trial for 6 straight weeks, every single day. So again, that first 2 minutes is important. Again, for me, from a defense standpoint, I talk about patience. I hit it. I spent a lot of time on it. I have different examples. I just shared one with you on a Starbucks, but come up with your own, whatever you like. From there, obviously, from a defense standpoint, the next biggest thing is sympathy and emotion. Before I go there, Vic, anything on your end?
No, I think, but just to close up what you were saying, look, everybody's different. Everyone has different personalities. You have to be genuine to yourself, because if you're not, if you're trying to fake it and trying to be someone that you're not in front of a jury, trying to be more animated and you're not, that's really not your personality. They'll see right through it, right? We're asking them to be honest, and we ask for their brutal honesty. And so I think also we need to play that part and be true to ourselves, because I think the jury's smarter than we think they are, and they're watching what we do as well. Just like we're watching them, they're doing the same with us.
Thanks, Vic. Okay, so the next thing I say is, hey, ladies and gentlemen, another thing that the judge is going to give you, the judge is going to give you the law that you have to follow. And by the way, that can be a tough situation. And so I will go into, hey, is everyone comfortable following the law that the judge likes to follow, that the judge gives you? You guys are the judges of the facts. You're going to determine this case. You're going to talk about the evidence. You're going to weigh the evidence. You're going to talk about a decision in this case. But the judge is going to give you the law that you have to follow. And one of those laws is you can't base this case, you can't make a decision on this case based on sympathy or emotion or passion. That's one of the laws he's going to give you. And the reason why we want that is we want you to decide this case based on the facts and evidence from that witness chair. From the facts and evidence, not from emotion and passion because we feel bad for the plaintiff. Listen, ladies and gentlemen, this is a hard one. I'm a super visceral person. So you can't just walk through those doors back there and there's a little box and says, put your emotion and your passion and your sympathy in the box and then sit in this jury box. I understand that's not that easy to do, but it's important that you understand what the judge is giving you in terms of law on that issue, that you have to set that aside and decide this case based on the facts and circumstances. So even though plaintiff may have a catastrophic injury, may not have a catastrophic injury, you have to determine whether or not my client caused that, whether or not there's shared responsibility, there's arguments of pre-existing. You have to weigh all of those things. And we don't want you to be swayed by sympathy. So opening frame, I threw a few out there. All of us are sympathetic as to anyone who's been hurt. That's just human nature. That's a good thing. Does everyone agree with that? By a show of hands, everyone agrees. By a show of hands, does everyone appreciate what I'm trying to say? That we need to put that sympathy aside and just based on the evidence and the facts, decide this case. That's really hard to do. Can everyone do that? By a show of hands, raise your hand if you can do that. Again, the judge is going to instruct you on that. And by the way, I do go when we talk about patience, I do say the judge is going to give you an instruction over and over again. Don't talk amongst yourself. Don't go home. Don't talk about. And the reason why that's so important. So I forgot to say that. I'm going to talk about that law first. So again, this is going to be hard. I'm not going to pretend it's easy. But do you think you can follow that instruction? And listen, the judge is going to give you the law that you have to follow. And sometimes that's hard. Let me give you an example. Flag burning in the United States is legal as a matter of law because a federal judge has determined that that's not a violation, that is in accord with free speech, provided it's not associated with violence. I strongly disagree with that. I don't want flag burning. So I would have a hard time following that law in that case. But I understand as a juror, if that was the law the judge gave me, flag burning in and of itself is not illegal in the United States. Can you accept that? As a juror, I have to accept that. So the judge is going to give you the law. I think you're going to agree with 99% of it, I would imagine. But that's the law you guys have to follow. And again, one of those laws is sympathy and emotion. You have to set that aside. Another one of those admonitions is don't talk amongst yourself until you get in the jury room and you've heard all the evidence in totality and you've given Mr. Bremer, the defense lawyer, a chance to cross and put his or her case on, my case on. Okay? So again, on sympathy and emotion, I spent a lot of time on sympathy and emotion. Is that hard for you? Can each of you put that issue aside? We all have sympathy, but can you follow the law? Is there anyone who feels when someone's harmed, it's impossible to separate emotion from legal responsibility? So if you were selected as a juror and you did feel sympathy for the plaintiff, but you felt plaintiff had not met the burden of proof with respect to certain issues, could you, in that setting, decide against the plaintiff on an issue? That's really the big question. As empathetic as we may all be for the injury, if plaintiff doesn't meet the burden of proof, can you say that the plaintiff takes nothing? Raise your hand if you can't do that. Now, I'd like you to raise your hand if you can. If at the end of the day, no matter how bad or how sorry I feel for the fact that the plaintiff was injured, and I'm acknowledging, ladies and gentlemen, the plaintiff was unequivocally injured in this case. Can you award plaintiff nothing if plaintiff doesn't meet the burden of proof? Thank you, ladies and gentlemen. So, even if you have bad feelings, let's see what it says. Plaintiff's story is emotional. So the next thing I would talk about is I lost my train of thought there. Give me 1 second. Sympathy and emotion. Okay. So I want to get into for cause challenges, but I think I'm missing something. Oh, I wanted to talk next about burden of proof. So that slides nicely into when you're finding it, what's the evidence, what's the burden of proof? So many times this happens. In fact, it happened the other day with Dan Kramer and Robert Glassman, where they talked to the jury first, and they talked about the burden of proof, and they talked about criminal, and it's beyond a reasonable doubt. And then in our case, it's a preponderance. And what's a preponderance? It's the scales of justice. It's a feather. So I'll get up there and say, hey, ladies and gentlemen, I understand that plaintiff talked a little bit about the burden of proof. I'd like to talk a little bit about the burden of proof with you. And I appreciate that plaintiff used an illustration or talked about a feather, but that's really not what's going to happen in this case. It's really not what the law is. The judge is going to give you the law that you have to follow. And what the judge is going to say is it's a preponderance of the evidence. And plaintiff has the burden of proof. And the preponderance of the evidence is different. Plaintiff has a burden of proof that they have to make in this case. So the law says plaintiff must prove each element of their case by a preponderance of the evidence, meaning more likely than not 51%. The plaintiff has to prove an issue by 51%. If you're undecided and you can't decide if the evidence is, say, 50-50 or equal, then notwithstanding whether plaintiff was heard or not heard, you would award plaintiff nothing. So that's the burden of proof. So plaintiff has the burden of proof. Does everyone understand that? And I know we're not doing this, ladies and gentlemen, but if everyone was to go back to the jury room right now to deliberate, you would find for the defendant because there's been no evidence. So they're at 50-50 right now. The two white pieces of paper remain white. The two horses remain at the starting gate. Okay? And again, I want everyone, by a show of hands, if plaintiff does not meet the burden of proof as it relates to a certain issue, and you're going to have a number of issues to decide here, damages, liability, allocation of responsibility, can you vote no against plaintiff, even though we're sympathetic or empathetic to the fact that he or she was injured, if in fact they didn't meet the burden of proof for you? I see everyone's raised their hand, so thank you. And then from there, I would probably go into anchoring. I would start looking at my for cause jurors and talk a little bit about them. So let's talk a little bit about anchoring. So you just heard plaintiff ask, if the evidence supported an award of millions of dollars, would you be comfortable with that? So here's where I'm going to have a couple of jurors that I want to go after, and I'm going to target. Now listen, when you're going after a juror or you're targeting them, again, this is not sport. And I've seen in voir dire, both plaintiff and defense lawyers really go after a juror, and you have to be careful. It's a great place to offend the jury pool. This is a person that's being honest and forthright in terms of impartiality, where he or she's coming from on an opinion, i.e. I'm critical of someone who doesn't speak English that's been in our country for 20 years. It would be easy for plaintiff to attack that person and then try to establish a bias or even a prejudice and then say that person for cause cannot be fair and impartial because the defense is going to have a head start because the plaintiff doesn't speak English. That's not what happened the other day. Dan did a great job, and he kept going with this guy, talking a little bit about it and opened it up, and then he moved on. So when we talk about anchoring, it's where the plaintiff says, the plaintiff gets up and says, I'm going to be asking for a lot of money in this case. My client was really, really hurt. I want you to appreciate that. And you're going to be asked whether or not you can award. There's two types of monetary damages. One is out of pocket. Those are called special damages, where we have the receipts. And one is called general damages, and that's for pain and suffering. And listen, there's two schools of thought. There's a school on one side that says, hey, I'm not in favor of people getting pain and suffering. I'm good with the receipts. And then there's a school of thought that says, well, of course, if someone has some pain and suffering, they should be awarded. By a show of hands, who's in the school of, I'm not comfortable giving an award of damages for pain and suffering? So that's what a plaintiff's going to do and start to go down that road and then talk about, are you good with me asking for millions and millions and millions, and then getting the jury to say yes. And I'm going to find out which jurors I might be annoyed with, and I might go for cause at that point. Let me quickly just jump into for cause before I go into anchoring. So what I would do, what my spiel is with regard to for cause is, I say, I appreciate what you told the plaintiff there, that, you have a cap. You have a cap. So this is called rehabilitation. I would be rehabilitating this witness if he or she said that they believe in caps and that they couldn't be fair and that they couldn't award anything over that. I would say, hey, I understand that in voir dire that you told the plaintiff that you're not comfortable with pain and suffering, that you'd have caps. And you don't know what the caps are, but there's a limit to what you would award. But you haven't heard the facts or the evidence. And again, we have no evidence in this case, so we have no idea what this case is about. But if the facts and circumstances warranted an award of millions and millions or something above your cap, you wouldn't know that yet. Is it fair to say that you wouldn't know that yet because you haven't heard the facts and evidence? That's fair. So if I was to tell you that the defendant in this case was Osama bin Laden, would you still have a cap or would you not? So most jurors are going to say they probably wouldn't in that situation. I'm going to say, well, clearly Osama bin Laden isn't our defendant in this case. But again, that was a new fact that I just added that would come into evidence that the defendant is Osama bin Laden. So I'm asking you, can you be patient and can you wait for the coffee to be brewed before you make a decision because you haven't heard the facts and evidence? So if in fact plaintiff does do an amazing job and puts on the case and is able to show that the case is worth millions and millions, is that something you would be comfortable considering based on the facts and evidence that come in here? So that's how I might rehabilitate someone as it relates to money. On my own side of it, when someone says to me, I'm very sympathetic to someone who gets hit on a motorcycle. I think that people don't see motorcycles. I ride a motorcycle, and I really think motorcyclists get the short end of the stick because they're loud, people don't like them. And I would get up there and say, listen, you'd agree we have two white pieces of paper, but in your situation, as a result of your life experiences, which I respect, and I love your love of cycles, and I'm thinking about getting a tattoo with a motorcycle. So I'm on board with you here. So that being said, would you agree that you've already got the plaintiff horse a little bit ahead of the defendant horse because the plaintiff's riding a motorcycle and you think potentially people don't see the motorcycle, they don't pay attention to those things? Is the horse a little bit ahead in the starting ground? Or on your piece of paper, do you have a little bit more you've written already before we got started as it relates to the plaintiff in this case because of your sympathy and your prior experience? I might have a little bit. And I appreciate that I want to put that horse back in the starting gate with you. But it sounds like as a result of your life experiences, you're someone that just couldn't be fair and impartial in this case, and that you'd put that horse a little bit ahead. That's probably true. I probably would do that. And I don't care what the plaintiff comes up here and says or does. At the end of the day, you're a little bit more ahead with it relates to the plaintiff than the defendant, correct? And again, even if the judge was to ask you some more questions, for you, you believe that horse is just a little bit ahead as we get started here. And that's fair, because remember, I'm not judging pie eating contests because I hate cherry pie and you might make a cherry pie. So in that case, the lemons and the other pies, the apples, have a little bit of a head start. Are you in the same boat? I am. So I've kind of boxed him or her in a little bit and I'm going for cause. And that's sort of how I go about doing that. Vickis?
Yeah, I wanted to go back and touch a little bit on the anchoring. So I know you talked about plaintiffs going to get in there and they may, ask a question and say that they're going to ask for a certain amount of money, and if people will be offended by that, et cetera. So, if plaintiff's counsel walks in there and says, hey, if we were to ask for $1 billion in this case, would anyone feel that just too much, that no one's worth that? And then from the defense side, I don't think, and Keith, I don't know if you disagree with me, that you can't afford to just let it sit unchallenged. I think you don't have to necessarily refute the number, but I think you have to sort of reframe it as a claim that requires some sort of proof. And so in that hypothetical about the $1 billion, I think a question, paraphrasing is, does anyone here expect that if someone asked for that kind of money, that they would have to show exactly how they got there and provide some sort of proof? I think from a defense side, you don't necessarily have to give a number, but I think you can't afford to just let it sit unchallenged and don't say anything to that. So, I'm sure you get that all the time when plaintiff's counsel coming in on these high-profile cases and they're giving a number. Do you give a defense perspective without giving a number, but you don't just let it go, right? I mean, from the defense side, you want to reframe that.
Exactly. So does everyone here appreciate that a cup of coffee is $3.99 at Starbucks in San Bernardino on the corner here? And that cup of coffee, that $3.99 has the exact same value as $1 in that jury room when you go back there. Does everyone agree that $1 outside the courtroom has the exact same value as $1 in the jury courtroom, in the jury voir dire room where you're going to be deliberating? So remember that, ladies and gentlemen, that I'm empowering you to be the judges of the facts, and I want you to be reasonable. And if you conclude that plaintiff is entitled to damages, plaintiff is entitled to reasonable damages, real dollars. The same dollar that's outside the courtroom out there. The same house that's worth $500,000 outside this courtroom is worth $500,000 inside this courtroom. So I might do that just to kind of remind them of the value of $1. And then I'll go through a little bit of of individual damages. So in this case, plaintiff is claiming damages to portions of his or her body, or making claims for damages to conditions that we don't believe were proximately caused by this accident. So I would then say, in this case, if I'm able to show, let's just say that plaintiff's claiming he caught a cold as a result of this rear end car accident. If I was able to show that that cold was not caused by this rear end accident, fair to state that you would say the plaintiff didn't meet the burden of proof. You could award plaintiff 0 as it relates to plaintiff catching a cold as a result of this accident. I know I'm being sarcastic, everyone, but do you follow what I'm saying? So in the same breath, to the extent plaintiff claims he's got a lower back problem, and we claim that's a pre-existing problem and wasn't caused by this accident, similar to a cold, could you, again, if plaintiff doesn't meet the burden of proof and you hear our experts and you decide the plaintiff didn't, could you award plaintiff 0 on that low back issue, on that traumatic brain injury issue? So I might start off with a cold. I've got some other examples. I've used the example of if plaintiff claims that he or she lost their hearing as a result of this T-bone accident, and didn't prove that they couldn't have lost it, although I've had hearing cases actually. But I've used hearing, common cold, ear infection as an example to try to say that, plaintiff claims a brain injury in this case. We claim plaintiff had, yes, a brain injury, a minor concussion. Plaintiff was good almost overnight and released from the hospital. But again, plaintiff claims it's something more. You're the judges of the facts. I'm empowering you to make that decision. But if in fact plaintiff doesn't show that injury is as extensive, like the ear infection, as plaintiff's claim, can you give plaintiff 0 on the TBI if that's justified? And again, can you give plaintiff $100? So again, when plaintiff said, Vic, can you give millions and millions? If in fact plaintiff doesn't meet the burden of proof, or in fact, if you in the jury room find reasonableness to be 500,000, even though plaintiff asked for 5 million, can you award the plaintiff 500,000, even though plaintiff has given you that figure of 5 million? You're going to make your own decision. You're the judge of the facts. You're comfortable with that. Fair? So that's how I kind of deal with money. Vic, did I answer your question?
Yeah, you did. That was great. Thank you.
So,
and then kind of going into that, so like if you're admitting fault, right? If you admit fault and we're sometimes
let's talk about that real quick, Vic.
Okay.
So really fast. I don't really stipulate to admitting fault. I generally will do that in voir dire. I will get up and say, ladies and gentlemen, we're admitting that we caused this accident. We take full responsibility. We feel terrible about it. The facts for you as the judge of the facts in this case is what is plaintiff's damages. There's a recent case out there that says that the time and place in which you stipulate to liability cannot be used as evidence against you. I will, generally speaking, tell the plaintiff lawyer, hey, I will stipulate to liability, but I want to be the first one that says it in voir dire. If we have that agreement, I'll stip to liability, and if we don't, then I won't. And I may still do it even if plaintiff doesn't. 9 times out of 10, the plaintiff will stipulate with me, and we'll have a gentleman's agreement, and we can go from there on that issue, Vic. I just want to hit a couple of quick issues. There's obviously, you want to talk about defense. We talk about lien treatment and financial motivation. How many of you know what it means when medical treatment is put on a lien? By a raise of hands. So that's a situation where a doctor gets paid when the plaintiff gets a verdict in this case. So he or she might be working off of a lien. You're going to hear about that in this case. Has anyone ever had any treatment provided to him or her by a doctor that was on a lien? Anyone here have such an experience? Does anyone have concerns about whether a doctor might overtreat or recommend unnecessary treatment when they're only paid if the case is successful? So there are little questions you can start to go into, and you want to kind of lay the foundation on liens. We've got damage reality check questions, problem jurors. Just find your areas. You've got gaps in treatment. You want to talk about that. Who here believes that if someone is truly injured in an accident, they need to see a doctor right away, and that they need to keep treating and they need to take care of themselves? They have an affirmative obligation to mitigate their damages, to take care of themselves and not let it exacerbate and get worse at the cost of another party who's admitted liability. Who here understands that theory? So there's all kinds of little anecdotes. I want to just give you a couple other headings I'm not going to hit because I'm 1 minute away from opening it up. Again, authenticity is super important. Be yourself, be open, be honest. Credibility matters. I get into discovery. If I know that plaintiff has answered questions in discovery that are going to be contradicted in his or her testimony on the witness stand, I talk about whether they're familiar with the legal process, if they know what discovery is, that the judge is going to instruct them that written discovery has the exact same weight as if they took that witness stand. Does people appreciate that? So while you might not see it, I'm going to read it. Do you appreciate that the judge is going to give you law that you have to follow that? So even if the live testimony seems more powerful, can you give them equal weight if the judge tells you that's what you have to do as a matter of law? So I'll go through discovery. I'll talk about whether they believe people sometimes overstate injuries in a legal setting because they want to get money. Do you believe that people exaggerate their injuries? There's a lot of billboards out there promising millions and millions of dollars to you if you can get in a car accident. Do you think that people take advantage of that situation? Are you offended by the billboards that you see in LA? Why? Do you believe that it's the promise of a new day to someone who gets rear-ended? Or do you believe they're entitled to just reasonable compensation? So there's all kinds of little things you can say. We talked about stipulating the liability. There's countering the reptile theory. If plaintiff says your verdict protects the community, does that sway you? Judges aren't going to allow this these days, but sometimes accidents just happen. Should defendant be punished as an example if an accident just happens? I've got another, talk about expert witnesses. Again, I'm going to have a list in my voir dire. It's going to be about 6 pages. I'm generally going to get to my top 15 issues, and I'm not going to get to my bottom ones. Does anybody here hate lawyers? Why do you hate lawyers? There's shitty mailmen. There's good mailmen. So you got to kind of have your little themes that you're doing on your heading. So I think that's where we're at, and we've got 4 minutes left, Vic.
I think you did a great job. Yeah, that was good. Thank you.
All right. We wanted to open it up for questioning, and I see we've got some questioning now. If we don't have anyone popping in here, I'll finish.
So it looks like we do have a few questions. Christopher Rose asks, how do you defend in the face of incontrovertible evidence like the video of the ICE shooting now in the headlines? How to voir dire the jury to, to believe ICE in this case?
Right. So in that case, I would acknowledge that the video, a picture's worth 1,000 words. I'd get up there on behalf of ICE and say, listen, a picture's worth 1,000 words, and you're going to be the judge of the facts, and you get to determine what happened. But again, you're not going to hear any sound, and you're going to hear the evidence of what those officers subjectively believed and where they were at and what their threats were and what their concerns are. Can you keep an open mind as to what happened out there and listen to my client tell you what he or she said out there? Or do you believe that you can't? Now, I would start by getting people who are prejudiced against ICE. I would try to get into the Trump conservative versus liberal issue because I think it's relevant in this case as to whether they're polarized. I would be having a for-cause heyday in that trial. But I would acknowledge that a picture's worth 1,000 words, that you, the jury, get to weigh that picture. I'm not going to argue with the video. But what I am going to show you is I'm going to present evidence of the officer. He's going to take the stand. He's going to talk about what he subjectively believed, what he felt, what she yelled at him, what he thought he heard, what the circumstances were, whether he felt his officers were threatened. Can you keep an open mind, or do you believe, just based on the video and what you've seen in the media already, that plaintiff has a little bit of a head start? So in a civil matter, that's what I would say. And then say, and you couldn't reverse that. You can't get back. You can't keep an open mind and wait to hear from my client, can you? And then I would try to get him for cause.
Great, thank you. And then I do have someone asking, can you repeat the name of the podcast that you'd referenced earlier? I think you'd mentioned something at about 20 minutes or so.
John Morgan's, I don't know the name of John Morgan's podcast, but if you Google John Morgan on podcasts, it'll come up.
And let's see. Sarah Petrani asks, how do you approach jurors who stay quiet during voir dire? What cues or follow-up techniques help you assess whether they're neutral, disengaged, etc.?
So I'm definitely someone who wants to touch everybody really quick. I try to quickly touch everybody. And so I'll say juror number 7. I know that you haven't raised your hand. This is as intimidating of a setting for me as it is probably for you. Let me just start by saying thank you for being here. I know it'd be easy not to have come. Second, have you heard anything here that's kind of offensive to you or anywhere, or something that you said yourself? I totally disagree with what I just heard there. Have you heard that? And they're going to say no and say, how about something you loved? There's two sides to every story, right? Some groups come in, even on that ICE thing, I would say, there's going to be two factors, right? There's going to be two factions in this ICE thing. I've already seen it in the media, ladies and gentlemen. There's going to be the group that says that ICE guy could do no wrong. He could have shot her point blank, blah, blah. And there's going to be the other side that said, oh my God, it doesn't matter what happened in that circumstance. She could have come out with a machete 1 foot from his face, and they'd say, you can't shoot her. So there are the polarizations. Have you seen that in this case, ma'am? And is there something you totally do agree with? I want to know. So I would try to get them to agree with something or disagree to get the conversation started. You know, I like to say that I'm like the boyfriend that showed up for the first time at Thanksgiving, and nobody really wants him. You know, you got to try to win them over a little bit in that setting.
Alrighty, well, that looks like that's it for questions. Any other closing remarks you'd like to make?
Again, I would just end where I started is you got to finish strong. So, and I don't mean, you know, a real hammer or anything like that. Just like have a question or two ready that are going to resonate. Hey, thank you so much. This has been an amazing experience. I just want to confirm, to the extent plaintiff isn't able to prove at the end of the day a certain issue, for example, the traumatic brain injury, everyone by a show of hands, are you comfortable to tell the plaintiff, I don't believe you have a traumatic brain injury? By show of hands, the plaintiff doesn't meet the burden of proof. Can you give plaintiff nothing on the traumatic brain injury? So just something that's within your theme of your ending, you know, if it's shared responsibility or comparative fault, even though it looks like someone ran a red light, but we saw the guy coming in a freight truck, you know, could there be comparative? Can you keep an open mind? End strong with something that resonates.
Yeah, and I'll just say thank you for the opportunity. Obviously, Keith and I are available if anyone wants to reach out or follow up on anything that we talked about.
I agree with that. Thank you, Vic, for saying that. Yeah, so everyone has our email. I'm on Instagram. If you want to try to find me at KBeasy Senior, you can hit me there. I'm happy to help out anyone, anytime.
All right, perfect. Well, this concludes today's presentation. Thank you so much, Keith and Vic, for an excellent presentation. And thank you so much to our audience. Have a great day, everybody.
Thank you. Take care, everyone.
Bye.
Bye-bye.